And our guest this hour knows all about the Dorn case. Criminal defense attorney Adam Johnson standing by for us live in Minneapolis. Adam, great to see you. Thank you for coming on the program and educating us about this case. I know you have written an article on it, and not just that, I understand you even presented a seminar to a group of prosecutors about this case. You know it so well. So educate us, take us to school, simplify it as best you can. What exactly does this case, Dorn, mean for the Chauvin case?
Well, thanks, Julian. It's nice to see you. This case developed a few years back. There was some turbulence in the law. It's, I think, settled now, and the prosecutor we just watched gave a correct iteration of what the case law is. The facts from Dorn serve as a good example. In that case, Allie Dorn is at a bonfire in northern Minnesota and overhears someone at the fire refer to her as a drug dealer, and she becomes upset about that, pushes him, and then pushes him again. He falls back and suffers severe burns in a bonfire. Her defense at trial was that she never intended the harm from her conduct, and the court convicted her. It was a court trial that went up on appeal. The appellate courts eventually arrived at the rule of law that is, the defendant does not need to intend the consequences of the act, only the act itself. It's the volitional act that matters. And so long as the person intended to commit an act, and that act resulted in harm, irrespective of the degree of harm, the defendant can be on the hook for criminal liability, ranging from fifth-degree assault all the way up to a first-degree assault.
You know, Adam, I appreciate that. This sounds to me like this Dorn case has almost made it easier for prosecutors when they go about trying to prove a second-degree murder charge by way of establishing the assaultive behavior as the underlying felony. Is that a good way to kind of further explain it?
I think so. On the surface, it may seem that a second-degree murder charge is going to be just inherently more difficult to prove than second-degree manslaughter, for example, or third-degree murder with depraved mind. But the underlying elemental nature of the second-degree unintentional murder offense requires only that the prosecutor prove the death. That's obvious here. Also, causation. That's a question in this trial that's been hotly disputed. But then with regard to the defendant's intent, the only requirement is that the state prove that the defendant committed the act, not that the defendant intended the final result of that act.
Mm-hmm. So the defendant doesn't have to intend harm, just to commit an act, and then whatever happens as a result is what happens. So in this case, could we apply that definition you gave us, and you really explained it well, Adam? Let's apply that to the Derek Chauvin case. What are the prosecutors trying to do in terms of their analysis? What might we hear in closing arguments when they take the law and marry it to the facts?
So the lowest level of assault, which is obviously where they're going to try to tie their case, is the third-degree felony assault offense in Minnesota. That requires the state to prove that the defendant intended an act that eventually caused substantial bodily harm to another. And if you have a death, you, by nature of that death, have automatically substantial bodily harm.
So then the kneeling on George Floyd's neck, that could be an act?
That could be an act. Walking past somebody in a crowd and pushing somebody to the side to get to the front of a line can be the act. If that person fell over and broke their leg, you could be charged with an assault crime in Minnesota.
Adam Johnson, this is great stuff. Appreciate the definition. It's important that we understand this as we go into closing arguments and then, of course, the verdict watch. You're going to stay with us. We appreciate that, and we appreciate all you at home.